go through both Chapter 25 and Chapter 26, basic agency law. And one of the things that we consider with agency is, how are they, what's the area of law that it comes from? And some of you already done your homework on Chapter 25, and a lot of people say, well, it must be agency law. Well, that's true, of course. It's sort of a bootstrap argument. But basically, it stems from traditional contract principles, the rules and laws related to agency contract principles. It's pretty straightforward, the two chapters. I think students do much better on this testing material that comes a little bit later, so that's a note of optimism for those of you that want to boost your grade a little bit. I think this stuff is more digestible for people, and I think they do better on the exams when we get to that portion. Generally, what is an agent? Well, an agent is someone that acts on behalf of a principal. So if I asked my attorney to go do and buy certain things for me or engage in certain contractual obligations for me with some third party, that is what an agency is in a nutshell. Someone being able to contract on somebody else's behalf. That's all agency is. It's very, very common. It comes up all the time. And there's often disputes about whether someone was really an agent and whether or not they had the authority to act on the principal. And there's lawsuits that stem between all three parties. So there's only three parties involved: principal, the one that's delegating sort of authority, if you will, to an agent to contract on their behalf with some third party. That's the definition in a nutshell. It's pretty straightforward. Why is it important to discuss? It's critical. So many things done in business are done through agency. I know in my own law practice, I almost do all criminal law now, but at one time I did a lot of real estate stuff, and especially in real estate, there are many agents involved. Now, you have to be careful. We do call salespeople agents, and we call brokers agents of the sale, but they're not true agents in the sense that they have the power to contractually bind one of the parties in there. But I, as an attorney, sometimes did things in real estate where I had the power to act on behalf of another person through what's called the power of attorney. Now, you do not have to be an attorney to have the power of attorney in certain circumstances. We'll get to that in a minute. So what powers may be delegated to an agent? Almost everything, except those that are so sacred to the individual, we think they're either inappropriate to delegate or they're really unlawful to delegate. Things like, I don't have time to go vote, so you go vote on my behalf. I don't mind. I use your judgment. You and I have the same kind of outlook on the world. Go vote in the presidential election on my behalf, and you go vote yourself too. And I'm fine with that. You can't do that. Things like voting, things like serving in the military. And at one time, you could do that. By the way, you could actually pay someone to serve in your behalf as basically an agent during conscription, during, I believe it was the Civil War. They had it right up through. So most powers can be delegated, and a surprising amount of them can be delegated. Going back to the Chapter 13 on third-party contracts, we know that most rights can be assigned, and that's true of most agency abilities are pretty broad, pretty significant. What are the ones in the book that tell you can't do? You can't vote in a public election. Executing a will, that's the actual testator, the one that wants to write the will, has to be the one that signs it and execute it. Serving on a jury. Imagine that. Hey, a jury duty next week. You go sit on my behalf. There's so many nuances that get involved in that we wouldn't have a broad spectrum of the community being representative if we always could basically delegate that authority to an agent. So it's kind of common sense. Who may appoint an agent? Pretty much anybody that is of sound mind. It's the same as contract. Remember I said most of agency law is contract law. And so remember we went back to contract. Who can contract? Competent people can contract. And it's a very low threshold, and we presume competency exists in people. So, and who may act as an agent? The same analysis. An agent just simply has to be a competent person, and usually an adult. If it's a minor, that's either the principal, or a minor, that's the agent. Most of those contracts are not void, but voidable in most jurisdictions, and we don't want to get too much into that. Classification of agents: general agent versus special agent. That sounds pretty 007-ish and kind of cool. I'll start with special agent. I've been a special agent many times in my law practice. A special agent is someone given authority to work in a very specific area, do a specific thing. And so I go to closing sometimes on behalf of a seller. The seller's already signed the deed, but there's other documents that have to be signed at closing. They give me a power of attorney simply to execute documents related to the sale and transfer of title at 123 Green Street in the city of Gardner, for example. That's a special agent. My authority is very narrow, very prescribed and subscribed to a zone of authority. A general agent is much broader. And that would be something like if you hire me to run your convenience store, fairly wealthy, maybe you have several convenience stores, you're now staying most of the time in Martha's Vineyard, but you still don't want to give up the convenience store. You hire me as your agent to run that one of the franchises. You probably have not necessarily listed all the powers in the agency. Maybe we haven't even put it down into writing. It might just be oral. But there's obviously certain apparent authority and implied authority. So in order to run a convenience store, you probably don't expect me to run it 24/7, 7 days a week. You expect me to hire employees. You expect me to pay for and buy and contract to bring in goods to sell at your convenience store. You probably have an expectation I contract on your behalf to maybe maintain insurance on the building, to deal with consumers and to contract with them that come in the store. So that's called a general agent. They have broad authority to do all that which the principal could do in running some business or entity that's customarily in that realm. I think it's fairly common sense. Special agents, I'm not going to mention this, is factors. Factors basically take merchandise or property for somebody else and have the power to transfer title to a third party. Those are consignment sales, for example. A factor is decreditor. That's basically putting a promise that the goods will be bought on credit. In the agent is guaranteeing that the credit situation will be paid for, though they're basically backing up the debtor. Now, brokers and attorneys, in fact, I'll just say brokers real quick. Careful on that one. Brokers, as a general principle, that term broker, that does mean that they have the power to negotiate and sell certain kinds of property to third parties. It does not apply to real estate. For example, I am a real estate broker. I do not have the power to convey title on behalf of my client. I only have the power to do what? And this is what most brokers do anyways, not just real estate brokers. Brokers bring together the seller and the buyer so they may ultimately consummate a contract, but they don't have the power to actually contract. So it's a little different than a true agency, because what is a true agent? A true agent has the power to enter into a contract on behalf of the principal with the third party. Brokers just bring them together, hopefully already having a sense of what the mutual meeting of the minds will be, but the ultimate agreement and being bound has to be done by the principal and the agent, brokers. And that's what a real estate broker really does. They just bring together the buyer and the seller to agree upon terms, and then they get a commission. Attorneys, in fact, might as well spend a little time on that because it's real practical. You do not have to be a lawyer to be an attorney, in fact, and that's why it's an unfortunate name. We sometimes call these powers of attorney. Do you have a power of attorney? I just helped my friend get one recently on behalf of his mother. Actually just passed, but for a period of time, his mother was pretty sick, mentally fine, but sick physically, and she was not ambulatory, meaning she couldn't move around, she couldn't get to the bank, she couldn't do things like that. And so she needed to get checks signed and deposited and certain decisions made and real estate taxes paid, and she certainly wouldn't be able to do that electronically. She was in her 90s, and I think she still had a rotary phone just before she died, so technology was way out of her wheelhouse of ability. So she appointed her son as attorney, in fact. In Massachusetts, as in most states, to have the power of attorney, or an attorney in fact, we usually call it power of attorney, it does have to be in writing. It has to be signed by the principal, and it usually has to be witnessed and notarized. The reason why we want to notarize, it shows that a certain degree of proof that the principal wanted to convey that authority to the agent. These tend to be not all-inclusive. They don't say, hey, I give Jim the power of attorney to do anything on my behalf. I had one for my father, for example, before he died. I was his attorney, in fact, and so was my sister. He had two of them out there, which can be dangerous, but our family's close, so there was no issue there. But what it allowed me to do was all his financial transactions for him. So any money coming in, any money going out, any bills that needed to be paid, I could do that on his behalf, because we were worried he might slip into some kind of a state where he might not have mental awareness. Now, here's what's interesting. It's called a durable power of attorney. Some of you, I don't think it's in the book, but some of you might want to know about this. I might have heard of it before. A durable power of attorney is made while someone's mentally well at that moment, but they're fearful that down the road they may become unwell. I sometimes have elderly couples, and I used to do estate planning. They might say, geez, I'm worried, what if I develop dementia? What if I become incompetent? Well, today, maybe you want to write up a durable, springing power of attorney that only becomes effective once you become incapacitated mentally or physically or both. And then the person would be able to act on your behalf. Powers of attorney stay viable when the principal is mentally incompetent if you put in that term durable, that it'll last during the period of incompetency. It does not last after death. And I've had people try to say, no, I got to cash my mother's check. And I say, mother's check? I just went to her wake last week with you. What are you talking about? And he goes, yeah, but I have a power of attorney and it's durable. Well, nothing's so durable to survive death. Powers of attorney die when the principal dies. Nothing survives death other than an estate, which just really comes about after death. So I don't get a little too technical, but you get the idea what a power of attorney is. Basically granting somebody very specific authority. It's a formal document, has to be in writing, has to be signed by the principal and notarized. Because sometimes these have to be recorded. Like if I went to the bank and said, here, I'm going to cash my dad's big old check. And they're looking at me and goes, well, you're not Joe Corman, you're Jim Corman. Like, yeah, my dad consents. He gave me a power of attorney. They give me an oral one. Well, the banks don't want, society doesn't want people ripping each other off by saying, I have authority to do something on someone else's behalf. So they're going to want a notarized copy of the power of attorney to keep in their records in case anyone tried to sue them for not protecting the bank account or the assets of the client they have a contract with. Kind of makes sense. And again, the extensive authority, usually there's express authority when I write these things, powers of attorney. I want to be very specific. Usually they're for loved ones to another loved one when it's a power of attorney. So it can be a bit broad. However, when it comes to more in the business realm, which this class is about, you want to be pretty specific. You don't want people basically giving a lot of authority. And what's one of the practical things you might want to get out of this little lecture here is when you do give a power of attorney where people might be able to open accounts on your behalf, spend money on your accounts, and make contracts on your behalf, run a business on your behalf, you could get, you can get ripped off. And what you might want to do is consider getting an insurance policy. It's called being bonded. You have those critical employees bonded because they have access to money and receipts and power that could basically bankrupt you otherwise. And so if you do get ripped off, you try to get the money back, but maybe they had a gambling problem or a drug problem, they may be sort of, I hate to say it, kind of bankrupted or dead end to get the money back. It's all gone. But you can go to that insurance company called the bondsman and try to get the money out of them because your employee or your agent violated their fiduciary duty to protect funds and assets on behalf of the agency agreement. So the extensive authority, the express, that's outright clearly written, but there's also implied authority. Like if you gave me authority to do certain things, obviously other things that might not have been listed are inherently within them. You can't say I have authority to sell your bicycle collection that's located in such and such a barn, but you didn't give me authority to enter the barn. It's implied. I mean, how is somebody going to get to the goods and have them transferred or sold or put in a museum or whatever it is that you gave me authority to do as your agent? So there's certain implicit things out there. There's also something called a parent authority. And this is where a lot of lawsuits come about. If I had a law office, for example, and I had maybe an office administrator, it's a fairly large firm, and they often have administrators. They're often paralegals, and they move up the ranks, and they become a very trusted member of the firm. And we have to do things like hire staff. We have to buy or rent or lease Xerox machines and enter into subscriptions with electronic databases that cover law. Maybe rent the building that we're in or pay leases, hire people, buy supplies and paper and cut checks to the court for filing fees. All of those things might be overtly done, and believe it or not, you can actually have a type of authority related to agency that's implied, and that's my point, related to a parent authority. Once you give somebody and let the world know they can do certain actions on your behalf, and yet you might say, well, they can do anything, but they certainly couldn't purchase anything more than $500. But if that wasn't advertised to third parties, would it be implied and therefore give a parent authority that they may be able to bind you, the principal, because it looked apparent on its face? So just an old war story I'll tell you real quick. Back in 1992, I had a case where something called a Dodge Viper had come out. There was very few production models come out that very first, I think it was 92, came out that first year. This is now 1994. The lawsuit was taking that long. I worked for this firm. And he worked for a rogue agent. What do I mean by an agent? He worked at a certain dealership. I don't even remember where it was, so I'm just going to make up a name, Smith dealership. He went in there, he went to talk to an agent. He said, I want to buy one of these new Dodge Vipers that are coming out. And the guy had a jacket on that had the name of the dealership. He had a desk, a little like kiosk, and what do you call those things? It was called cubby holes, but the desk with the little partitions around them. He had a name tag that had also the indica of the dealership on it. He met with the guy, took $500, or I think it was $3,000 cash. He said he'll get the first production vehicle that shows up at the dealership. That guy stops back in a month. He's looking around for this guy, Steve. Steve doesn't work here anymore. Steve's gone. He goes, well, I gave him $3,000. He didn't have anything. He had something written up, but it was just basically like kind of didn't look like a very formal contract. And guess what the ownership said? That's not a contract. He didn't have the express authority to sell cars without having a supervisor consent on that. My client's argument was, but he was clothed both literally and figuratively with the apparent authority to enter into contracts and sell motor vehicles. So we sued that dealership, and the lawsuit was getting very close to a jury trial when I had left the firm, and they were starting to offer a little bit of money, basically as deposit back. But we think what probably happened was there was a guy that just started working at this dealership, probably didn't have the actual authority to do so, but he seemed to have the apparent authority. He had access to these little outlines to make up a proposed deal that was right in his desk, and we made all those arguments. And I think it would be reasonable for a consumer to think that that sales agent had the power to enter into a contract on behalf of Chrysler Motor Corp, and that was our argument. But it wasn't a clear argument, because even the attorney on the other side said, wait a minute, this is a limited production vehicle. They weren't even sure they were supposed to be getting one. The reality was why there was such a big lawsuit over it is we were suing for more than just the value of the car, because we were suing for the value of the car, but because he was going to pay something like $56,000 for the car. The interesting thing was the car was going to be able to be sold for well over $100,000 once my client got it, because there were so few purchased, and that's my client's goal, was to buy it and sell it very quickly. Their argument was, well, why would we ever sell it for that amount? And that's a pretty good argument. I don't know where the case ever settled, but apparent authority is very, very scary because, I've had agents before. I worked at law firms, right? Employees, and sometimes employees are agents, sometimes employees are not. What is an agent and an employee? An agent is someone that might be your employee, but they also have the power to go out and engage with third parties, enter contracts on your behalf. So be very cautious, because sometimes by the way in which we act, the way in which we behave, the way in which we hold out these people, it may well look like they have apparent authority. And what if I gave them express authority in the past to work with Staples, and I have an account there, and they're always dealing with my former paralegal, Deb, and Deb was always purchasing everything from laptops for the firm and paper and office furniture, and then one day she goes nuts and buys a bunch of that stuff, but it's really for her home. And I can say, hey, Staples, we're not paying for this. Deb went rogue on us. She went, I think Staples have a very good argument based upon the customary behavior in the past that we gave her apparent authority to enter into those contracts, because we had in the past certainly paid for those amounts. And that's another way to create one. So there's express, there's implicit, but there's also something called ratification. Sometimes someone can just go out and pretend that they're an agent of my company, and they go out and pretend and do it. What if they do something I really liked? I shouldn't be able to have the concern to say, oh, now I'm out of that contract because I didn't really give them authority. I can ratify. And that's in the book too, about the concept of the different forms of which way you do it. One is by clear overt appointment, that's express. The other is this ratification concept, where basically somebody goes out and says, I work for Jim Corman's law firm and we're going to rent this building, and they go and do it, and I get a bill, and I said, but thank God you got this great building at a great price, and it's got parking, and it's right near the courthouse, and it's just going to take a little touch-ups, and you got to be a 5-year lease. I'll ratify it because you got me a great deal. And sometimes people go out there and hustle and try to do these, basically, I call them rogue, because they're not have the authority to do those things, but they're hoping that the principal will be so impressed or pleased with the contract they entered into their behalf that they'll ratify it. Estoppel, that relates to apparent authority. Estoppel is that, Corman, you can't say that you shouldn't be bound to this contract because Louis, who is with you all the time, and you told the world that Louis is my right-hand person. He does all my business for me. He lays the groundwork for everything I need to get done so I can just go to court. He does everything. And if I basically put him out in that apparent authority, even though I told Louis secretly not to do anything, you're not to engage in any contract, you're just kind of more of a show person, window dressing for whatever silly reason, I would be a stop from denying the existence of the apparent authority in that situation. And then necessity, that doesn't come too much, but sometimes parents are bound to children's contracts if it's for necessity, medical care, things like that. And same with me. If I don't know, I'm in the mall for actually went to the mall for the first time since COVID with my son to get him some new sneakers. He's 15, and I feel bad we haven't spent nearly as much time as we should since we're together all the time, but we don't do anything fun. So we went to the mall, and I haven't wore, I was going to call it a gas mask, but I haven't worn a face mask for that long a period of time, walking through the mall for that long up in Natick. And I nearly passed out. Imagine I pass out. Could I be entered into a contract by, say my other son was there, my adult son, and he didn't have any authority to enter into medical, but by necessity I would be bound into the contract. Sometimes agents do have to exercise through necessity things on behalf of their principal. Now I do want to talk a little bit, this is going to take a little longer, and I was hoping to get 2 videos into one. I'm going to go a little faster, but I do want to distinguish what's the difference between an independent contractor and an employee. And it's huge because employees have rights, independent contractors tend to have few. Employers have much bigger obligations when they have an employee than they do when they have an independent contractor. As a general principle, the guiding litmus test is how much control and for the duration does the principal have over the worker. So if I hire someone based upon their expertise and knowledge for one project, I hire a plumber to come into my business to put new toilets and fixtures into my business, that person's an independent contractor. I don't control how they do the work. I don't guide them specifically how it should be done. I don't dictate their hours, and I don't control the nature of the protocol about which they go about doing their business. An employee would be usually either for a longer period of time, or it would be open-ended. I control their hours. I specifically give them tasks and duties, and I control how they do their work and when they do it. It's a fine line. Is there a gradient scale? Do we argue about it all the time? Yeah, we do. And why do we get into this argument? Employers sometimes want to cast the characterization that someone working for them isn't really an employee because they don't have to pay Social Security tax on their behalf. They may not have to pay health care. They may not have to pay other benefits that would be due an employee, including workers' compensation coverage. It saves the employer a lot of money. But what happens to the employee? The employee later on, they're getting this check every week. Nothing's taken out. And then at the end of the year, they find out they got to pay taxes on $40,000 of income at a much higher rate that their employer would have been withholding for them and matching a certain fund. You pay more as an independent contractor in taxes than you would as if you were an employee. Plus, you get no benefits. So those kind of debates go back and forth all the time, and there's a lot of IRS rules and principles related to it. I don't know if it's a student in this class. I think someone was doing taxes as a business in one of my classes, and this is one of the concepts that come up. Do I get a 1099 at the end of the year, or do I get a W-2? And the contrast is very, very important. And it's also important for liability. Am I liable for the actions of my employees while they're in their course and scope of employment? As long as they're trying to do something that benefits the employer, even if it's rogue, I will be liable for my employees' conduct during the course and scope of their employment. Independent contractors who do something negligent that or injure someone else's property or persons, generally I am not negligent for, or I am not liable for, I should say, because they are independent. That's why we give them that very term. Very important concept. I think the book does a nice job on it, so I don't want to spend too much time. I want to get to operation and termination of the agency, the next chapter. What do agents owe their principles? Pretty straightforward. Loyalty and good faith. Loyalty is very important. Like, say, for example, I'm your agent. My job is to go out and find you the best rental sites for your new, what's a big chain right now? They're all dying in my opinion, but at one time, like Subway was real hot. I remember Friendly's as a kid. That's what my uncle did for many years as back when Friendly's was in its heyday. He went out and did site management. He'd go out and look for real estate to purchase on behalf or lease on behalf of Friendly's so the Friendly stores could be built there. He owes a duty of loyalty and good faith. What does that mean? He can't go out and say, wow, this is a great site for Friendly's, but I'm going to tell my buddies over at McDonald's to get a $5,000, finder's fee because I know they're really hunting for one in the town of Sturbridge, and this would be great for them. Now, that also relates to information. So loyalty and good faith is always owed to the principal. You can't keep secrets from them. You can't do double dealing, and you can't do self-dealing. This comes up sometimes in real estate. I might be trying to find a client a certain kind of home, and all of a sudden I'm looking through and I'm representing them, and I find something like, I love this for me. Now, there's a conflict of interest there, and you can't do self-dealing. It seems like common sense, but sometimes these things come up and they haunt you a little bit. and you find yourself in these really, awkward situations where you don't think you're doing anything immoral because well, you get excited over the opportunity that you're supposedly doing it for the principal, and it benefits you, your family, or your friends more, and you don't always think it should. Now, what if I conveyed it back to my principal about this property and they said, no, I don't want to go? I think you still owe a duty to disclose that you would like to maybe make that offer for yourself, or somebody you're close to, or family, or maybe another business. You should have that kind of candor. It's very important. Obedience, you have to obey everything. If your principal tells you you have to do X, Y, Z, and you decide to do some other things or do them differently, they have the right to terminate you and sue you for any damages if there's loss involved. They still have a right to terminate you, even if their disobedience made you a profit, it made you even more money, or put you in even a more beneficial situation. You have to abide by the agency agreement. You don't have a right to go rogue at any time. Reasonable skill and diligence. What does diligence mean? You got to try to do a good job. You can't be lazy and lackadaisical. You have a very high degree. It's called fiduciary duty. You must do the best you can. Accounting and information. Accounting is just that. They give me so much budget, I go out and spend the money. I have to be able to account for that. Hopefully receipts and proof and invoices. This is how I actually spend the money. I can't say, I don't know where the money went. Things were great, though. I had a great time. Things went well. I spent it all. Trust me, it was all on your behalf. You owe them in accounting. And the last one is information. And that comes up a lot. And I know people who I usually consider to be very decent human beings, where they're working in their agency capacity and they get information and they use it to self-serve, or they use it to serve their friends and family, and that's a violation of agency law. That's basically what the agent owes the principal. Pretty straightforward. But what does the principal owe the duty? Compensation. You get paid. Now, what if there's nothing in the agreement that says anything about paid? Does that mean there's no agency contract? No, there is. They have to pay you the reasonable value of the agent in that kind of realm, and the court will have to sometimes balance that. Sometimes we know because there's agency areas like running a store or something like that. There might be sort of an industry standard that ballpark would show an agent should get paid for that. Other things we'd have to determine what kind of skill and education and ability you had to bring to the fore in order to get paid. So my point is the contract would still be enforceable. We just have to figure out what would be reasonable compensation if the contract of agency didn't clearly spell it out. Reimbursement. So say I went the Mount had me as their agent to go represent them at some big consortium in New Orleans. Nothing was ever talked about transport or hotel or anything like that, but is it implicit that they're going to have to reimburse me for my cost of travel? As long as I took a private jet by myself and I stayed in the most fancy hotel, overlooking the bayou, and I got daily massages and I ate only the finest, what do they have down there? Not crabs, crayfish. It's got to be reasonable, but can you see, like all of a sudden at the end, I come back from a trip and I says, I spent X number of dollars on a traditional business coach flight out of Logan, and I stayed at, I don't know, a reasonable hotel. Just think about my father. We used to stay at the worst hotels when I was a kid. Good memories, but I don't want to relive them. So reimbursement. Indemnification is interesting. What if I got sued? I did something in my role as an agent, and I got sued because I did something negligent. Now, here's what's very interesting. This gets a little complicated. I won't test you on this, but think about it. I get sued. Basically, the principal does have to pay me back for any lawsuit that I suffer as a result, because I'm like an extension of them. But here's what's really strange. If I was negligent in the way I behaved, the principal actually has a right to sue me to get that money back, because by being negligent in my role, I'm actually breaching my agency agreement. Remember I said when you breach your agency duties, you have a right to be sued by the principal. That's rare. What isn't rare, though, is being indemnified. Think about it. I'm an agent for the Mount, and I go do something, and I don't know, I'm walking awkwardly, and I fall over, and I knock over a table of computers, and there's $25,000 of liability. They sue me. Can I basically ask the Mount to indemnify me? Absolutely. And abidance to the terms of the contract. So if it's an agency for a year and they terminate me earlier, they're violating the terms of the agreement. I have a right to sue them. That's the same on the other end. If I leave early, the agency was for a period of time, and I leave early, they can sue me for damages as well. Pretty straightforward. I like this chapter. It's a fun one to read. I don't think you need to listen to me all day. Basically say what the chapter's saying if the chapter's clear. And again, the third parties, I do want you to go over that pretty extensively. Oh, how do you terminate an agency? You can just do, the original agreement will say, it ends at the end of August. Well, then we know it's over at the end of August. That's by the terms of the agreement. Just like when does an offer end? sometimes we put right in there, this offer ends in 72 hours. Well, that's when it ends that way. Subsequent agreement, we can always come up with a new agreement to extend it, to change the terms, to end it earlier. So a subsequent agreement would certainly do that. Revocation. Either party, it's actually called renunciation if the agent does it, but just call it revocation for practical purposes. Language gets us scared sometimes, I get it. But either party can basically say, I'm done with this. I don't want you as my agent anymore. And the principal can say the same. I don't want you as my agent. Or did I say that already? The agent doesn't want to be part of the agency arrangement with the principal. I've actually seen this in a newspaper that lawyers get. It's called Lawyers Weekly. And every so often an attorney and a law firm have separated ways in a very bitter way, and you'll see attorney James Corman no longer works for the Acme Law Group. He's terminated. He has no power to represent us, to bind into contracts, to speak for us, or in any way, shape, or form. Usually that's bad blood, but there's also a fear that maybe I'd bind him into some kind of contracts in some way. So when there is an end of a termination, you might want to tell contracting parties that usually deal with that this party or this person is no longer an agent for our organization, because you're scared that they might go and do some acts that could hurt you. So that's revocation. And it's called renunciation if the agent does it. I don't know why we care about the different terms. And then termination by law. Remember, sometimes just like termination of law does that for contracts sometimes, like bankruptcy. That does it also for agents and principals. If either party, the principal or the agent, goes bankrupt, the agency is over. And they give it becomes illegal for the purpose. Right? Because sometimes it's not always criminal, but sometimes things are no longer allowed. Death or incapacity of either party. Careful, incapacity might allow you to still do it if there was a durable power of attorney. Destruction of the subject matter. There's no reason to keep the agency going. The subject of what the agency was for is gone. Bankruptcy. Dissolution. That's if a corporation no longer is legally in existence. That ends the agency agreement as well. And then war. I don't always know. We haven't had a declare war in this country since 1941. Believe it or not, that's the last declared war we had. So that's a little bit obscure. I don't know when that's going to come up. I don't know what circumstances. But I guess if we ever have a declared war against a legal entity as a country, that might affect or impact an agency agreement, and that would probably terminate it. I don't always know the circumstances. I went a little longer than I hoped. The material is pretty straightforward. And the good news for those of you that have some test anxiety or worried about your test grade, the tests, I think, do tend to trend upwards as we go near the end. So be well, stay safe, and I'll have another video up hopefully tomorrow or the next day.